In the previous chapter, you studied how ownership interests are created and classified: freehold, leasehold, life estates, and the bundle of rights that define property ownership. Now we turn to the limitations that can restrict or burden those rights. These are known as encumbrances and liens. Understanding these concepts is critical for every real estate professional because they directly affect marketable title, the ability to convey ownership that is free from disputes or claims. Before any sale or financing can occur, the title must be examined and cleared of encumbrances that might cloud or question ownership. 1. Encumbrances. An encumbrance is any right, claim, or interest in property held by someone other than the owner that limits the owner's use or reduces the property's value. Encumbrances do not transfer possession, they only burden the property. Yet, they are legally binding and can even lead to the loss of ownership if ignored, for example, through foreclosure. Encumbrances fall into two broad categories: those affecting use or enjoyment, such as easements, deed restrictions, or zoning laws. Those affecting title or ownership, such as liens, judgments, or unpaid taxes. Because nearly every property has at least one encumbrance, like utility easements, CC and RS, or mortgages, title companies perform title searches before closing to identify them. Anything unresolved becomes a cloud on title, which must be cleared before a transaction closes. Example: if a previous owner paid off a mortgage but never recorded the release, the lien still appears in the public record and clouds the title. The title officer would require a recorded satisfaction of mortgage before closing can proceed. When competing ownership claims exist, an owner can bring a quiet title action, a lawsuit that establishes ownership and removes all other claims. This ensures the title is quiet or undisputed. 2. Easements, encumbrances affecting use. An easement grants someone a non-possessory right to use another person's property for a specific purpose. Easements can exist on, above, or below the surface, such as driveways, access roads, power lines, or pipelines. The property benefiting from the easement is called the dominant estate, and the property burdened by it is the servient estate. Easements can be appurtenant, meaning they attach to the land and transfer with ownership, for example, a shared driveway between neighbors. Ingross, meaning they benefit a person or company rather than another parcel, for example, a utility line. Common types: easement appurtenant, transfers with the dominant estate automatically. Easement by necessity, court-ordered access to landlocked property. Prescriptive easement, created after 10 years of open, hostile, and continuous use without permission. Arizona's statutory period. Easement by estoppel, created when one party reasonably relies on another's permission and would suffer harm if it were revoked. Easement by implication, formed when a property division implies shared use, such as an existing driveway or irrigation ditch. Termination of easements. Easements may end by merger, same owner of both parcels. Release, abandonment, expiration, destruction of the purpose, or government condemnation. 3. Encroachments, licenses, and deed restrictions. Encroachment, a physical intrusion onto another's land, such as a fence or garage crossing the boundary line. Encroachments can reduce property value, and if unchallenged for 10 years in Arizona, may mature into a prescriptive easement. License, a revocable personal privilege to enter or use another's property. It does not transfer with the land and ends upon the death of either party or sale of the property. Deed restrictions, covenants and conditions. Private rules recorded in deeds or subdivision plats that govern land use. They are typically enforced by homeowners associations, HOAS, or developers to maintain uniformity and value. Covenants are enforceable by injunction. Conditions can result in reversion of ownership if violated. Deed restrictions may be stricter but never looser than zoning regulations. 4. Liens, encumbrances affecting ownership. A lien is a legal claim against property as security for the payment of a debt or obligation. Unlike easements, liens represent financial encumbrances rather than use restrictions. The person or entity owed money is the lienor, creditor, and the property owner is the lienee, debtor. Liens restrict the owner's ability to transfer or refinance until satisfied. They also establish a priority order among creditors if foreclosure occurs. Creation of liens. Contractual, voluntary, created by agreement, such as a mortgage or deed of trust. Statutory, involuntary, imposed by law, such as property tax liens or mechanics liens. Equitable, created by courts based on fairness to prevent unjust enrichment or fraud. Legal features. A lien does not convey ownership except in title theory states. A lien attaches to the property, not the person. A lien remains until paid and released. Multiple liens may coexist and are prioritized for repayment. 5. Types and classification of liens category. Definition. Examples. Voluntary owner willingly places lien. Mortgage, deed of trust. Involuntary imposed by law or court. Tax lien, judgment lien, mechanics lien. General affects all property owned by debtor. Income tax lien, estate lien. Specific attaches to one property. Mortgage, property tax lien. Superior takes automatic priority by statute. Real estate tax, special assessment. Junior inferior, paid after superior liens. Mortgages, judgments, mechanics liens unless otherwise prioritized. 6. Lien priority. Priority determines who gets paid first if property is foreclosed or sold. The general rule is first in time, first in right. The earliest recorded lien is paid first. However, some liens, like property taxes, are automatically superior by law. Arizona practice. Real estate taxes and special assessments are always first. Mechanics liens date back to when work began, not when recorded. Mortgages and trust deeds follow by recordation date. Judgment liens and junior mortgages follow after. Subordination agreements. Line holders may voluntarily change their order by signing a subordination agreement, often required when refinancing. 7. Arizona's mechanics lien and 20-day preliminary notice. Under Arizona law, contractors, laborers, or suppliers must file a 20-day preliminary notice to preserve their right to record a mechanics lien. The notice must be delivered within 20 days of first providing labor or materials. Be sent to the property owner, lender, and general contractor. Be served by certified or registered mail. If unpaid, the contractor may then record a mechanics lien, which takes priority from the date work began, protecting those who improved the property's value. 8. Foreclosure, lien enforcement. When debts remain unpaid, lien holders can enforce their rights through foreclosure. Judicial foreclosure requires a court proceeding, common for mortgages. Non-judicial foreclosure, authorized by a power of sale clause in a deed of trust. The trustee sells property without court involvement. Strict foreclosure, rare. Court transfers title directly to lender. Arizona primarily uses non-judicial foreclosure under a deed of trust. Borrowers may reinstate the loan before sale but have no redemption right after the sale. Anti-deficiency laws protect homeowners of certain small residential properties, 2.5 acres or less, 1 to 2 units, purchase money loans, from owing any balance beyond the foreclosure sale. 9. Practical applications. A real estate professional must be able to identify liens and encumbrances in title reports. Explain how they affect financing, insurance, and resale. Work with title officers to clear or subordinate liens. Advise clients about easement rights and restrictions. Recognize when a quiet title or release document is needed. Review. Summary encumbrances limit ownership rights without transferring possession. They fall into 2 major groups: use limitations, easements, restrictions, encroachments. Ownership limitations, liens. Liens are financial claims. Easements and covenants control how land is used. Lien priority dictates who gets paid first upon foreclosure, with taxes and special assessments always superior. Arizona's laws governing easements, mechanics liens, and anti-deficiency protections ensure fairness for owners, lenders, and contractors alike. Discussion 1. Why is marketable title crucial before closing? Answer: it ensures ownership can transfer free from disputes, liens, or encumbrances that could later challenge title. 2. What is the difference between an easement and a lien? Answer: an easement grants a right of use. A lien is a financial claim securing debt repayment. 3. Why do property tax liens take first priority? Answer: they fund essential public services and are automatically superior by law. 4. What document removes a lien once paid? Answer: a recorded lien release or satisfaction clears the encumbrance from public record.